So we're in the middle of a rip-roaring college football season. Ohio State looks like it's going to the Final Four, the college playoff. Once again, big games still remain this week against Penn State, down the road against Michigan. The University of Cincinnati very much alive for a New Year's Six bowl game, very much alive for a championship in its final year in the American Conference before it moves to the Big 12. But the undercurrent of football at all levels, including college football, the undercurrent is what physically happens to the human body when the competition is taking place and then years later when it is all said and done. And there is a lawsuit that is ready to go in California, in Los Angeles, alleging that the NCAA failed to protect a former University of Southern California football player from repetitive head trauma. The jury has been seated in this case. It is a wrongful death suit filed by the widow of the player by the name of Matthew G., former USC linebacker who died in 2018 from permanent brain damage caused by countless blows to the head while he took playing in the 1990 Rose Bowl winning team, same team that had Junior Seau on it. And, of course, Junior Seau took his own life, largely attributed to CTE, which is repeated head trauma leading to multiple concussions, and then because of that, severe psychological deficiencies. And G was 49 years old when he died, one of 5 linebackers on that Southern Cal team who died before turning 50. And as with Seau, who killed himself in 2012, G's brain was examined posthumously, and he was found to have CTE. This is going to have wide-reaching ramifications, I think, in football on a number of different levels. About 6-7 years ago, the NCAA agreed to settle a class-action concussion lawsuit and paid $70 million to monitor the medical conditions of former college athletes. The NFL has a similar plan in play, but we saw here a couple of Thursday nights ago when Tua Tagovailoa went down with a concussion. It isn't all that great. So what's going on here? What could the jury decide? And if it decides, what does it mean for the future of competitive football? Standing by to weigh in, Rob Crain. We've had Rob on the show before, nationally renowned personal injury attorney, and has been constantly on the list of the best lawyers in America. And Rob Crain, how are you on this glorious Wednesday?
I'm doing good, Ken. Good to hear your voice.
Yeah, good to hear yours too, Rob. And let's talk about this. You operate deep in the heart of Texas, football country. We're up here in Ohio, football country. We know all about the sport. We grew up either playing it or watching it or both. What do you think the chances of this case getting a favorable situation, settlement, or ruling for the plaintiff in this case, the widow of Matthew G.? What do you think her chances are?
Well, there have been hundreds of claims filed in the past, and only one has gotten to the trial, and it never resulted in a jury verdict. This is the second to get to trial. And, if you're the defense, like the NCAA, you don't want the case with the worst damages going first to a jury verdict. And this case is, my guess, is probably one of the stronger cases for the defense because of when it happened back in 1990 as far as his playing time and what the state of the science was back in 1990, because CTE wasn't even discovered until 2002. So this is going to be a difficult case for the plaintiff in that regard of proving the state of the art, that the NCAA knew about it, that they should have been doing much different things, as well as his cause of death is going to be it's going to be challenged as well because initially it was thought to be alcohol and drug related. Now we do know those things come along with CTE, but to your point, this is a challenging case for the plaintiffs, which means if they do get a favorable verdict, then it's likely to open the floodgates up to the NCAA. So it's one for their sake, they better win.
Permit this, because I'm not a lawyer. I'm just, an average citizen here. I mean, you're the lawyer, but is this any way, can an analogy be drawn here to somebody who, for example, smoked for a living and died of lung cancer in the 70s, when back in the 40s he might have been smoking like a chimney and there were no warnings from the federal government. There was nothing other than it looked like the social thing to do. This was an elective thing that in this hypothetical situation this person did. This is an elective thing that this player chose to do. Any analogy you could draw between those two things?
Yeah, I think there are some analogies. I mean, do people assume the risk of the health consequences from smoking? Well, nowadays, people know what the dangers are. But they, as you noted, didn't know in the 30s and 40s. We all played football, as you mentioned, growing up, and we realized that you get your bell rung and you might, folks do get concussions. But we weren't aware of CTE then, nor were we, aware of those damaging long-term effects. And likewise, that's where the tobacco companies, that's where they got in trouble, is they said all along, well, we didn't know the health risk, and then it was discovered, oh, wait a minute, they did know the health risk doing their own studies, and they didn't warn the public. So, coming back to where we are here is, well, when did the NCAA, when did the NFL appreciate and recognize these long-term consequences from repeated head injuries, and did they fail to warn in a timely manner? So, yes, your analogy is correct. The difference will be factually, when did the NCAA, when did the NFL have an appreciation of these dangers, and did they take the reasonable steps thereafter?
And and obviously, like any trial, it all depends on the jury. And the minute you go to a trial and it's a jury, well, then you're rolling the dice. All the work you do ahead of time to try and make sure you've got the right jurors in the stand doesn't guarantee that you're going to get the outcome you want. It sounds like you think, like this earlier trial, I think it was in 2018, for a player that played in the 60s. It sounds like you think this is going to get settled. I mean, to the NCAA, which is a big business fighting for survival right now with its football. The football looks like it could be sailing off into an entity of its own. I think the last thing the NCAA wants is this thing to go to a jury and that jury to start deliberating. It sounds like you think there probably is going to be a settlement here. Am I right?
That's a good question. It may be that it very well ends up in a settlement fairly quickly, but it may be the NCAA has decided, this case has our best facts, and we're going to take this one to a verdict to hopefully stem the tide of more claims happening. So they're making a calculated risk one way or the other. I'm sure they'd be able to resolve this for some amount, and they may choose to roll the dice to try to set precedent that future claims may not be successful. So they're making a business decision here. And so I don't know whether they're looking at resolving this once the jury gets seated, which it is seated. There's 8 women, 6 men. So it looks like they've got a couple of alternates included in there. But it may be a calculated risk that they're going to take to verdict. We'll see.
Rob, I'm sure you do this. I think most attorneys do. It's play it out. If you decide to go a certain course, well, let's play it out. Best case, worst case scenario. If indeed the NCAA wants this to go to trial, wants this to go to a jury verdict, and it loses, monetarily, it's one thing. The stigma on football right now is that it is a sport that creates trauma to the body and particularly to the brain. And this could change the course of competitive football if indeed this goes to the kind of settlement or the kind of course I just described. I often said the most powerful person in football isn't the NFL commissioner, it's the mother of a 6-year-old boy. And if she doesn't want the kid to play, the kid's not going to play. And that kind of dries up the pipeline from that level of football to high school to college and on into the NFL. This is something that, although it is a very real and tangible game of jeopardy for the NCAA, and in this case, the family of Matthew G., it also could, if you play it out, change the way football looks, or if it even exists the way it looks 15, 20 years from now, right?
No, Ken, you're spot on. And then look at the changes that have already occurred in football. And I'm a big football fan. I'm a 28-year season ticket holder for my college alma mater. So I'm a big lover of college football like you are. But I'm also a pro student athlete individual. And so you look at the changes that have occurred over football the targeting penalties that are now, the discouragement from helmet-to-helmet contact, the protecting of quarterbacks who are the ones that are, got the target on them. Not that they're the only ones who have these injuries. They're not. The people who inflict the pain, like the linebackers you're talking about, those rules are there to protect not just the quarterback, for them as well. What I think is going to need to be out there for that parent of a 6-year-old, and I'm one of them. I'm a late in life father, and I've got a 6-year-old who looks like a football player, is what is the technology going to be in addition to the rule changes? Are we going to utilize the helmet technology that's present day, that's state of the art, and going into the future, such that we still have hard shell outward helmets? Why? Why do we have hard shell outward helmets? What is going to happen with the rule changes and the equipment changes, such that we're minimizing these concussions and head injuries? So I think that's where the confidence level is going to come or go for those parents of those children, as you noted, and I'll be interested to see what happens.
You represent, for the moment, the NCAA. Do you tell them to settle? Goodness. What I would do, is I don't know the facts, all of them. I've heard the opening arguments. I wouldn't have made some of the opening arguments the NCAA made. They look like they were doing a little bit of victim blaming on this, which is not a good thing to do, in my opinion. So I would have definitely changed how I approach this jury. What I would be focused on, you've got a class action settlement in place. I know you're dealing with a whole lot of claims. You got to do the calculus here of, hey, let's be proactive to minimize any future claims, and then see how that looks with the table of claims you have. And if you've got to go try a case and try to get a verdict on it from a business standpoint, that's your business decision. As a lawyer, I'm going to be looking at navigating this in a reasonable way, so that we minimize the losses financially, but most importantly, show consciousness about minimizing injuries to individuals. That's what's going to go the most in public opinion. I would take a full, as we do with all our cases, we take a full, broad look at what does this mean. First of all, what is our behavior? Our behavior needs to be above board. We need to be protecting our student athletes any way and every way we can, and we need to be doing that not just publicly, but privately. That would be the first step, and then do the analysis and evaluation. That's for them to make. I don't know all the facts. I can't give them that. But my first piece of advice would be make sure you're doing the right things right now to prevent these kinds of injuries going forward. Honestly, it sounds like the NCAA should have hired you. I mean, that's to me, that's maybe they're saying the same thing, but that would have been the opening discussion, and to me that would have just laid out the pathway, the road ahead for everything. Good insight, Rob. As always, great insight. Thank you for your time, and stay well. We need to hear your voice. Thank you.
Anytime, Ken.
Rob Crain. They use those helmets. You've seen the pictures that have that they're not a hard shell. There's soft padding around the outside of the helmet, and they're used in practice. NFL teams use those in practice. Why not use those during a game? And even more so if you're playing at a level where there are very young kids and you want your child to play football. Look, if that's a decision you make as a parent, then that's fine. It should be your decision whether or not your kid plays football. Personally, I wouldn't let my kid play football until he's at least 10, maybe a little bit older than that. We know the brain isn't developed completely until a child is 16, 17 years old. If it's not developed completely, there is more room inside the actual skull for that brain to get rattled around. But if you choose to allow your kid to play, then why not insist on equipment that will protect that kid as much as possible and right through the NFL? Why not? I mean, is it the sound of plastic hitting plastic? I mean, is that an attraction? I think as we get more educated in CTE, I think you're going to see the game of football change from the way it's played and what they wear and how it's governed. This Tua Tagovailoa thing that happened here a couple of weeks ago, it's not a standalone, isolated thing. I honestly think now, and you can see it in the way games are being officiated in the wake of that it is a game that is going to be drastically, I think, different in the next 10 years. Best part about it, we get to see if it will or it won't. It's 1:25, News Radio 700 WLW.